still give me the, okay. Right now? Oh, great. Okay. Wonderful. Well, thanks for having me here today. My name is Angela Hayes. I'm an attorney here in Spokane, and I work for a company called Associated Industries, and we are an employers membership organization that provides a range of services to businesses of all sizes, from two-person organizations all the way up to very large organizations with hundreds and even, maybe 1,000 plus employees. So I spend most of my time working with our member organizations by phone, email, doing training in person, talking about all different kinds of employment law related issues. So this isn't dealing with business structures or structuring your organization. It all has to do with your employees and managing the employment relationship with folks in your organization. So again, we're going to talk about just really at some 30,000 foot high level. I tried to pick out a few basic items to talk about with respect to employees and employment in the state of Washington. Currently, we've had a lot of developments, both at actually at the state and federal level over the past couple of years. So I think it's a good time if maybe you've had some employment law training in the past, but a good refresher if you haven't. So again, there I am with longer hair. My disclaimer, of course, no lawyer would stand up here and talk to you without saying, I'm going to talk to you about some legal issues, but I'm not specifically giving you any legal advice while we're talking here today. And of course, we don't have any attorney-client privilege because none of you are my clients, and it's a whole bunch of unrelated people in the same room. So we can't establish attorney-client relationships when it's all of us, me against all of you and all the folks out there in the ether. So if you have questions, I would encourage you to talk to your own private legal counsel with respect to any of the issues that we're talking about today. I've left my email address at the back of the slide presentation, and I've also left some cards on the table. If you want to do a brief follow-up, you can send me an email, and I'm happy to do what I can to assist you or talk to you about membership with Associated Industries so you can get the full complement of the services that we provide here. So with that, I'm going to just jump right in. I had an opportunity to talk to some of you before we started here today because I wanted to see what the status was of the development of the businesses that you're all coming in with. It sounds like all the folks that are around the table today work for established businesses, whether you don't have employees yet and you're looking to add employees, or you work for an organization that already is established and has employees. The things that we're talking about today will apply to both of those employers equally. So I'm going to start off by talking about just touching on a couple of different things with respect to recruitment and hiring within your organization. So at the early stages of employment, when you're looking to bring somebody into your organization, what are some of the laws that might touch on that? What are some of the things you might think about doing or not doing? Just a general, again, 30,000 foot view here. In the state of Washington and all 49 states, with the exception of 49 states and Montana is the outlier in this, all employment is by default at-will employment. In all of the states except for Montana. And what that means is that people that you hire in your organization, they are at will. You can terminate their employment at any time for any reason, with or without notice. And those employees, likewise, can leave your employment with or without notice, with or without reason, at any time. So that's what at-will employment means. I get a lot of calls from employers that say, we're going to go ahead and let this person go. I just want to make sure this is 100% risk-free because these are at-will employees. And I would never say anything is absolutely risk-free. Again, at-will employment means that either party can end the employment relationship at any time, except for that an employer, there are some exceptions to at-will employment. So you want to think about this maybe when you're bringing people into your organization. Are you going to have these employees subject to written employment contracts? If you do have written employment contracts, sometimes employers will fashion them that say you remain an at-will employee, but these are the terms of your employment contract. That makes me a little bit nervous because you kind of have this hybrid situation. Are they employed with you by contract, or are they still really an at-will employee? Sometimes the things that employers will write into employment contracts really kind of change the tenor or the nature of at-will employment, saying, the employee is required to provide us with 2 weeks notice before they leave. That's going to change the employment relationship to something other than at-will. So you want to think about that if you are going to bring people in under some kind of written agreement or some kind of contract, that you continue to maintain the at-will relationship to the best that you can, while maybe, laying out some terms and conditions of their employment. Usually how I like to do it with employers is if you are going to bring somebody on, you're going to continue to have them at will, and you don't want to alter that relationship, that you simply provide the individual with an offer letter that outlines the terms that you're bringing them in on, what their job's going to be, who they're going to be reporting to, what their work hours are, what their wage is going to be expected to be, what the benefits are that they can expect to receive, and then some big disclaimer at the bottom: you are an at-will employee with our organization, and then have them sign the letter and return a copy of it to you. That nicely lays out what the terms are of their employment, but doesn't create a contract for employment for any given or specific period of time. So again, you might want to think about that when you're bringing on employees. But it is nice to have something in writing so that they can refer back to it, or so that there's no misunderstanding about, again, about what their job is, or about who they report to, or about the type of work that they're supposed to be doing for you in an organization. So express contracts, again, that's one way that you might alter the at-will relationship. Sometimes there might be an implied contract that you have either intentionally or accidentally in a written employee handbook, for example. So sometimes employers will have statements in an employee handbook that say, we will provide progressive discipline to employees, when you're having any kind of performance issue within the organization. Saying something like, we will provide progressive discipline, will tie the employer, basically create a contract between the employer and the employee that they will be providing progressive discipline to this employee, basically under all circumstances. So now you've lost your at-will capability to terminate somebody's employment at any time by saying something like that in a handbook. So better to fashion it by saying, we may provide progressive discipline if the circumstances warrant, at the sole discretion of the employer, for example. It gives you that wiggle room and ability to maintain the at-will employment relationship, but apply progressive discipline when that seems to be appropriate. Sometimes employers, too, will put somebody on a performance improvement plan. Now I'm getting outside of recruitment and hiring, but say you already have somebody in your employment and they're not performing up to snuff. You're going to put them on a written performance improvement plan. We're going to give you 3 months to kind of turn your ship around, meet these benchmarks, and during that time period, you'll be subject to the terms of this performance improvement plan. If you don't put something at the bottom of that performance improvement plan that says you remain an at-will employee with our organization, you may have just tied yourself to keeping this person in the employment of you for at least another 3 months while they make their way through that progressive, that performance improvement plan. So again, maintaining that at-will employment relationship at all times to the best that you can, I think, is really important when you're bringing employees on or when you have them within your organization. Sometimes, too, employers may want to terminate somebody who is appropriately an at-will employee, but say the employees just filed a workers' compensation claim, or maybe they just filed a whistleblower protection claim, or maybe they just used their paid sick leave benefits, or maybe they just filed a claim with the employer that they're being harassed or discriminated against in the workplace. If the employer turns around and terminates somebody in the face of one of those actions, it is very possible that the employer could appear to be retaliating, or maybe is actually intentionally retaliating against the employee for taking a protected or statutorily protected action. So in that way, the employee is also protected, from being technically an at-will employee. You could run afoul of at-will employment. They may be an at-will employee, but terminating somebody in the face of doing something that's protected by statute could get the employer into trouble, and you might want to think twice about doing that. Gosh, I went right beyond like we're hiring somebody, and now I'm already talking about firing them. And violation of anti-discrimination laws, of course, you can't fire somebody or end the employment relationship because of somebody's race, creed, color, national origin, disability, veteran status, pregnancy status, marital status, sexual orientation, gender identity, transgender status, any of those protected statuses that are protected by state or federal law. So that creates a huge exception to at-will employment because, again, there may be reasons that you want to terminate somebody, but sometimes you need to think about, are we going to run the risk because this person falls into a protected class? They just filed a whistleblower claim. They're a veteran, and they just left on their National Guard duty, and now we're going to turn around and fire them. That could create an appearance, at least, that you are taking some action in violation of one of these anti-discrimination laws. So again, I'm going to get back to recruitment and hiring. Now, we just fired all these people that we haven't even hired yet. So now, with respect to hiring now in the state of Washington, and there are a number of states now that employ these ban-the-box type rules. So this was a new statute that was implemented in Washington within the past couple of years, and likewise the city of Spokane actually had its own ordinance and still has its own ordinance with respect to hiring within city limits, and now even statewide we have a ban-the-box provision in our state. So these state and local laws really prohibit the employer from inquiring about criminal history prior to an interview. It doesn't mean that you can't conduct criminal background checks, and I would suggest that employers continue to use third-party consumer protection or consumer agencies to do those types of background checks, or sometimes employers like to do those on their own. I would encourage employers to continue to do that. This law doesn't mean that you can't do it. It just changes the timing about when you can have those conversations and ask for that type of information. So I would suggest when you are looking to hire employees, go back and take a look at your applications. Make sure that you have removed from your job applications any reference to or inquiry, do you have any arrests or felonies or convictions within the past, 7 or 10 years, somewhere in that time frame? You want to take that stuff off of the employment, off of the job application, whether that's online, whether it's a paper application. Make sure that that's not part of that hiring documentation anymore. Again, doesn't mean that you can't do it. It just means that you can't ask that kind of question outright on an employment application any longer. The ban the box rules, both at the state and the local level, prohibit employers from making inquiries in job advertisements, job applications, or conducting background checks, again, prior to an interview. So you can't list things in job advertisements or advertise for positions in a way that would exclude somebody that has a criminal history or a criminal record. So saying things like, convicted felons won't be hired, must have, or you can say things like must be able to pass a background screen. You can say things like that, but you can't say in the, in the job advertisement, don't bother applying, or, won't consider felons or something like that. So you can't advertise in a way that would discourage those individuals from hiring. You can't include, again, questions on your employment applications or ask the applicant orally about, or do any of your sub rosa investigation before somebody comes in, and conduct your own Washington State Patrol background check or something like that. You can't do it formally or informally prior, again, to having that interview with the individual. So in the timing of all of this, when you have extended or, you've kind of gone through your initial review of the applications, you're looking to see who's qualified, who has the training, experience, education that we're interested in interviewing, and you can bring all those individuals in for an interview. Maybe it's going to be a face-to-face interview, maybe it's going to be a Skype interview. The law does allow the employer then to ask about criminal background or criminal histories during the interview process. My recommendation would be, as a best practice, that you wait until the end of the interview to ask a question like that if you are indeed going to do it at that time. I have a lot of employers that don't even ask it during that initial interview. They will tell the individual, you're going to have to pass a background check. They're going to get ready to extend a job offer to the individual. They'll say you probably have to pass a drug screen and a background check. And then if something comes up, they'll give the individual an opportunity to explain. But if you are, I do have some employers that are bent on asking those questions during the interview. Again, I would recommend that you wait till the end of the interview and then, document that the question was asked at the end of the interview. Because if you ask it at the beginning of the interview, it's possible that the individual could come back and say, that was the first question that they started off the interview with. And then they didn't hear anything that I had to say after that. And they didn't take into account my training experience. They didn't even ask me questions about it, or if they did, once I told them, yes, I'd had a criminal conviction, 6 years ago, they didn't really hear or pay attention to or, give any weight to the information that I provided them afterward. If you let them go through the entire interview and you've given them an opportunity to explain to you their qualifications, their background, their training, their experience, I think you're better off then, if you want to ask the question, ask it at the end, because then you can, justifiably say, we did talk to the person about their qualifications, their background, their training and experience. We did ask them about their criminal background, their history. They told us that they had a conviction. And due to business necessity, we didn't think it was an individual that we wanted to proceed with, for example. So those are the things that you want to think about with respect to ban the box. So again, doesn't mean that you can't ask those questions, doesn't mean that you can't get that information. You definitely should. It's just a timing issue about when you can follow up on that. There are some industries in which you still can ask that outright because somebody's criminal history may ban them at all from being considered for a position. Those generally involve situations where you have individuals who will have unsupervised access to vulnerable adults or children. Those for sure are areas where a criminal conviction or criminal history will prohibitively prevent them from working in those certain areas. So if you work in an area that does require criminal background checks, this law may not necessarily apply to you, but generally it will apply, to most employers. Okay, there's also something in the state of Washington now called the Equal Pay and Opportunities Act. This was passed back in 2018, and then it was amended in 2019. So the original law that was passed in 2018 stated essentially that employers couldn't pay employees less than similarly situated employees of a different gender unless that pay differential was based on good faith bona fide factors other than gender that were job related and consistent with business necessity and accounted for the entire pay differential. So essentially what this means is that you can't pay two people who are essentially performing the same job different salaries or different wages based on the fact that they're different genders. And likewise, you can't give individuals of one gender different opportunities for advancement within an organization versus somebody of a different gender. So, for example, if you have within an organization a pattern or practice of, let's just say, a bunch of men getting together and going to play golf, and that is where a lot of business is transacted and happens, and that's where people get to know each other, and then people, generally their advancement opportunities are buffered by those relationships that they've developed. You certainly need to think about, as the employer, extending those same types of advancement opportunities to both genders in a workplace, because that can run afoul of this as well. And likewise, I think pay is obviously the obvious one, that you can't be paying two people who are performing essentially the same job different wages based solely on gender. And sometimes that will happen because of the next slide that we're going to talk about, but salary history inquiries, where somebody comes in and says, typically it would be a woman who had been paid less than a man, performing the same type of work. They indicate on their application that this was their salary, their last salary that they were making, and the employer uses that then as a starting point, and it continues then to perpetuate the pay differentiation between genders. So employers, or the law now says, again, that employers should be going back and doing reviews of individuals within their organizations of similarly situated employees to ensure that people that are performing the same types of jobs are being paid the same wage, or if there is a difference in their wage and they are different genders, that the employer better have some justified reasons and bona fide reasons that are consistent with business necessity for those. So similar jobs would be jobs that are based on skill, effort, and responsibility. It's not necessarily job titles. So two people could have different job titles, but they're essentially performing the same type of work, requires the same type of skill, education, licensure, certifications, and things of that nature. So employers shouldn't go solely on job titles, but make sure that it's the performance of the work, or the work that they're performing, that is going to be that similar job definition there. Differences in pay between employees in similar jobs, though, can be based on, again, some of these bona fide factors would be differences in education, training, and experience. So regardless of the gender, if somebody has more training, experience, education, licensure, certifications, things of that nature, they've had more experience than another person, that would be a bona fide factor in considering a wage difference between two individuals. Seniority, merit, quantity, and quality of work that somebody's performing, so you're looking to give somebody an advance or a pay increase within the organization. Some of the things that you could think about is the quantity and quality of work that these comparative individuals are performing. Regional differences in compensation, or differences in minimum wages. So you may have an organization that hopefully your organizations will grow. You'll be spanning many different states, or maybe you're spanning, some people are living on the west side, some people are living here on the east side. That may be a consideration because the standard of living and the cost of living is so disparate between the two sides. That might be a legitimate basis for paying individuals different amounts of money for actually performing the same or similar work. The Equal Pay and Opportunity Act also had a clause in it that says that employees have the right to disclose and discuss their own wages. So a lot of times employers might have in their handbooks statements that say employees' wages are private information and you cannot discuss them with other employees. That's for the employer's own morale. That's because the employer wants to protect itself from frustrated or disgruntled employees comparing their wages. That's no longer legal. So the employers, if you have a handbook, you want to make sure that you don't have anything like that in the handbook, or if you're going to draft a handbook, or you're considering Associated Industries or something like that to draft your handbook, we certainly wouldn't have anything in there like that. But just know that you can't tell employees that they can't discuss their wages, because they do have the right to do that. Human resources officers can't go out and tell everybody else what everybody else is making. Again, it's not their information to disclose, but the employees can disclose their own wage information and have those discussions among themselves. Yes.
Question: Are these laws that are specific to Washington? Do they, if you're working for a company outside of Washington but you reside in Washington, do they apply to you versus the company is headquartered here? How does that?
Sometimes it will require an intensive fact analysis, but the fact that you work for, say, for example, you work for a Washington company and you live in Idaho and you commute to work here, Washington law is going to apply to you. You work for an Idaho company, but you live in Washington and you drive across the border to work in Coeur d'Alene, this won't apply to you. Your residence won't be the state.
So if you work from home,
Yeah.
Is that, because that's happening more and more.
Right, and it will depend on, like, where do you get the direction from your work? Who do you report to? Where is that location? Where is the actual activity that you're performing? Are you a salesperson? Your home office is here in your Washington, in your Spokane, Washington home, and your sales territory is in Washington, but the headquarters of your organization is in North Carolina. Washington law is probably going to apply to you because you're actually working in Washington. The actual work that you're performing, it's not just you're in Washington because that's where you live. You're in Washington because your actual duties require you to be here in the state and performing work. So it sometimes can be a tricky analysis. It's not always necessarily black and white. So which is a great question. And a lot of employers, you're right, will require, for example, multiple handbooks because they have employees that are working all over, and there are different laws that might apply to, like if you have employees in California, that's like a totally different country. I mean, they have a whole bunch of, and Washington is actually kind of getting that way. We're a close second. So with respect to employee-friendly laws or employee-supportive laws. So employers will need to watch that. So when you are branching out and you have locations in different areas, or Montana is a good example because they have a lot of different laws, even though they're close by. It's very common to have employees in Montana or branch offices in Montana. Whole different set of employment laws are going to apply to those individuals, first and foremost being they're not an at-will employment state, and you can only terminate somebody for just cause after a certain number of days there. So you'd actually have to have a legitimate reason for terminating somebody's employment in the state of Montana. So that's a great question. Not easy to answer without knowing exactly what kind of work the employee is performing. But I think the fact that you have that level of awareness is important. So that, as I mentioned, the Equal Pay and Opportunities Act was amended in 2019 then to actually include an outright salary history ban. So prior to 2019, employers could still ask employees, maybe on their job applications, what was your prior salary, what's the last salary you were earning, what's the last hourly wage that you were earning, things of that nature. The law now has been amended to say employers can no longer ask those questions. So if you do have an application now that you use with employees, whether it's online, whether it's a paper application, you want to make sure that you've removed that question from your job application. So taking off the ban the box type questions and taking off the salary history questions from your application is going to be important. Employers are kind of trying to fudge their way around this by saying, what's your expected salary, or what are you expecting, so that they have, I guess, some idea. I don't know that that necessarily gives employers a really realistic sense about what employees, might necessarily be looking for. One of the things that employers should be prepared to do is to provide salary range information to individuals who ask for it. So that's part of the law that requires that employers have that information ready when it is asked for by employees. So a better way to get a really good feel about, is this going to be a good fit with the employee? Are we going to be paying them what they're expecting? Is to give the employee, or maybe in your job advertisement say, this is what the salary range is for this position, depending on qualifications or depending on experience. That way you're filtering out people maybe who have unrealistic expectations or who are looking for something different. But the employer then is putting forward and being forthright with what they're willing to pay somebody, again, giving themselves some wiggle room depending on the experience of the individual. So now, again, under this salary history inquiry ban, the employers are barred from seeking a job applicant's wage or salary directly from the applicant. Or indirectly through the applicant's current employer. So you can, again, do your sub rosa investigation about, do we have a convicted felon applying for a job, and they're, I want to know what they were making at your location. Can't be doing any of your own sub rosa investigation about that. There are exceptions to making these salary history inquiries. So except the employer may confirm the applicant's salary history where the applicant has voluntarily disclosed his or her salary history. So in the interview, and the employee or the applicant blurts out well, I'm currently making $75,000 a year, it would behoove you as the interviewer to document that that was disclosed. It was not solicited during the interview. It was disclosed voluntarily by the employee or by the applicant. They kind of blurted it out so that there's no question that it wasn't you soliciting the information from them. And if they do disclose that, then you have the opportunity, or you have the right under the law, to go ahead and follow up to confirm that that's actually the salary that they are currently making. Or the employer can confirm the salary history after the employer has negotiated with the applicant and made an offer of employment, including compensation. So once you've negotiated with the employer, you're going to extend a job offer to them, including a salary, then you can confirm what it is that they were making at a prior employer if you want to do that. So those are the exceptions there.
It seems like it's a little
Yes. Yeah. Yeah.
Prior to hiring, whereas really there's never a point. It seems
Correct.
like when you're authorized by the law
Until you've essentially extended a job offer to them, or unless the person,
just like
right,
confirming if you were to then
right, like did we hit the mark, or are we paying now? We're paying too much, or we're not paying enough. So yeah, you are right, and thank you for pointing that out. That's exactly right. Nope, you're exactly right. The ban the box does allow you to have that conversation at a certain point, even as early as the interview process. Salary history inquiry does not allow you to have that conversation unless the employees or the applicant has told you, or until you've already gone through the entire process and extended a job offer to them, and then you can go back and confirm. And then, like, it's kind of water under the bridge there, right? And probably from the employer standpoint, they probably don't want to know. I mean, by that time, it's like, ugh, I wish I hadn't done that. Or maybe they're happy, they think they're, getting a great deal. I'm not sure why an employer would want to do it at that point. So, also to know that the applicant's prior salary can't be a bona fide factor when you're justifying a pay differential. So you can't say, well, Angela was making $35,000 at a prior job, so we found that it was fair to, bump her up to 40. We thought that was great. Whereas, Jared, that was hired to do the same job, he was a good negotiator and he came in making $50,000, so we bumped him up to 55. That is not going to be a legitimate reason or bona fide factor in justifying a pay differential between me and Jared, who are performing the same type of work. So, and I can guarantee you, I'd probably be much more qualified than Jared. So there's no legitimate reason for that. I want to talk just a minute about social media in hiring. I think a lot of employers like to, there's nothing in the law that says you can't use social media in hiring. I would just caution employers to think a little bit about it. I think using things like LinkedIn and other professional sites, totally fine. I mean, I think that's where people go to hopefully honestly put on their best face. They're talking about their education, their training, their experience, the things that they can bring to the workplace. I think that's a good place to go if you want to use social media in the hiring process to go ahead and do what you can to find out as much information as you can about an applicant from something like LinkedIn or some other type of professional site. I think using things like Facebook and this is, I'm going to disclose my age. I can name 2 or 3 social media sites. Facebook, Instagram, that actually might be as far as I can go. TikTok, I don't think that's actually a social media site. But anyway, so when you're looking you Google somebody's name and you're looking on their Facebook page, and if they don't have enough sense to put on all the privacy filters and make sure that it's not open to the public, you may be accessing information that you then can't unsee, and you can't use that information in making hiring decisions legitimately. So if you see on somebody's Facebook page that they are actively involved in the LGBTQ community in Spokane, for example, and that may not be something that jives with your beliefs or whatever that you have, that's not acceptable to you. You can't use that. Now you can't unsee it. That is not a legitimate factor in deciding whether or not somebody would be an appropriate employee for your organization, and you can't use that to make decisions about their employment within your organization, even whether you're going to hire them. So, because that would be making an employment decision based on somebody's protected status, perhaps, or maybe you see something on their social media site and you can detect or you see there that they have a disability. And now the employer is like, I don't really want to know if I want to go through with the interview process and the hiring process of this individual, because I know we're going to get into a situation where we very may well have to accommodate somebody's disability, and that sounds like that's going to be a lot of work on the part of the employer. Now you can't unsee that information, and you also can't use that to make a decision about whether or not you want to hire that person in the organization. I have employers say all the time, well, how's somebody even going to know? I mean, how's somebody going to know that that was the reason that we didn't hire them? And I'm saying, well, they may not know, but they may decide they come in for the interview, and you decide not to hire them, and they go to the EEOC or the Washington State Human Rights Commission and say, I think I was just as qualified as all the other applicants, and I think the reason that they didn't hire me was because of my disability. Now you sit down for a deposition, or you get involved in some kind of legal kerfuffle about it, and you have to disclose, yeah, well, we were looking on their social media page, and I saw in their profile picture that they were using a wheelchair, or that they were, I learned information about their disability by looking on their social media site. So I want employers to know that you can do it. I would use it with caution. I would understand that some of the things that you see on social media, you can't use that information in making a determination about whether or not you want to have that person in your organization, or about whether or not they're qualified for the job. So you need to be wary of that, or you need to understand that. And sometimes the things that you see on social media maybe aren't true, maybe they aren't, they aren't accurate. So again, I think if you're going to use social media in hiring, sticking to the more professional sites, I think is a good way to go. Taking the things that you see on other social media sites, again, like Facebook, Instagram, things like that, kind of with a grain of salt, and understand that, sometimes the things that you see, if it falls within one of those protected statuses, it gives you information about somebody's race, their religion, their creed, their color, their disability, their veteran status, their marital status, their pregnancy status, the use of a service animal, their HIV status, their gender status, their gender identity status, their transgender status. Any of that you can see is very broad. Any of those protected statuses, you can't rely on or use that information to disqualify somebody from employment within your organization. Now, maybe you see pictures on Facebook or Instagram of people using drugs and partying and things like that, and you think like, those probably aren't protected statuses. Maybe we don't want somebody like that within our organization. That person looks like a drama queen already, and we haven't even hired them here. That might be a legitimate reason, but again, just you need to make sure that employers understand there's sometimes there can be a fine line between the things that you can use and you can't use, and you certainly can't unsee any of it once you've seen it. So be judicious, I think, and cautious in your use of that or reliance on it.
If I'm stalking somebody's social media profile, and
essentially employer-funded benefit for your employees that are subject to the minimum wage law. So this applies to your non-exempt employees, essentially. Not your exempt employees. They aren't necessarily covered by Washington State paid sick leave. Most employers do provide some kind of paid sick leave benefit to their exempt employees, but tech applies to employees who are covered by the Minimum Wage Act, and that would be your non-exempt hourly employees. So, and again, it applies to employers of all sizes, so there's no size threshold as to what employer has to provide paid sick leave. So non-exempt employees are earning 1 hour of paid leave for every 40 hours that they work, including overtime. So if they work 45 hours in the week, they continue to accrue or earn those sick leave benefits. There is no cap on the accrual that somebody can earn in a single year, and there is no cap on the number of hours that they can use in a single year. There is a cap, though, on how many hours the employee can carry over from year to year. So the state law does allow employers to cap the carryover of up to 40 hours that the employee can carry over into the next year. So if the employee ends the year, they haven't used it, they're a full-time employee, typically then would earn 52 hours in a year. They don't use any of it, they're perfectly healthy. They lose 12 hours of time, they carry over 40 into the next year. The employer could allow them to carry over all of it, but they don't have to. Only have to allow them to carry over 40 into the next year. And then additional sick leave hours are going to accrue on top of that. So they start out the year then with 40 hours, and they'll continue to accrue. And again, there's no cap on accrual. So say the employee rolls 40 hours over into the next year, they continue to accrue, they earn another 52 hours, so they end the year with 92 hours because they continue to be perfectly healthy. They're only going to carry over 40 into the next year, and they start over again then from that base. Employee is going to be eligible to use their accrued leave starting on the 90th calendar day of employment. Sometimes employers will want to use a PTO policy that they already had in place or a sick leave plan that they already had in place before this law went into effect. And if that's the case, I would encourage employers to go back and look at that policy to make sure that you will allow your employees to use that sick leave starting on the 90th day of employment. Because sometimes employers, for example, in a PTO plan say, and if your PTO plan is generous, like you give employees a paid benefit and they can use it for anything they want. They can use it for sick leave, they can use it for vacation, medical appointments, whatever. The employers can do that. They can continue to just use their PTO policy as long as it meets the minimum requirements that the state requires under paid sick leave. But you want to make sure that your PTO policy or any other existing policy that you have has been modified, if necessary, to say you can start using it on the 90th day of employment. Because again, sometimes a PTO plan will say you can't access the benefit until you've been here for 6 months or whatever. The employer could go ahead and continue to restrict use of PTO for things like vacations on that 6-month window. But if somebody's going to use that benefit for a reason that would come under paid sick leave, then they have to be able to use it on the 90th day of employment. The employer can require some notice if the need for leave is foreseeable, so the employee is going to take some time off for a medical appointment or something like that. They can require the employee to provide up to 10 days notice, as long as you have that in a written policy. Employer can also require verification that the leave was used for an authorized purpose only if the absences exceed 3 scheduled working days, and that also has to be in a specific written policy. So if the employer wants to make the employee bring a doctor's note to say the employee was out sick and they were using their paid sick leave benefits for an authorized purpose, you can only do that after the employee has missed 3 consecutive scheduled work days. So on the 4th day of absence, you could ask them to provide written verification that they were using the leave for an appropriate purpose. And it could be for the employee's own physical or mental health needs, so stomach flu, dental appointments, I need a mental health day. I know that a lot of employers that I've worked with have been finding employees who seem to be sick on Fridays and Mondays. That's a big problem. And there's really not a lot that employers can do about it, except hope that the employee burns up that leave fast enough that they're no longer able to, to do that. And that's an unfortunate thing. I get to be a cynic after, because no employer ever calls me to say, hey, things are going great. We just wanted to let you know that. All I hear about are the problems. So those are what I hear from employers, that they have a lot of employees who tend to have headaches on Mondays or something like that. And unfortunately for employers, there's not a lot you can do if they have paid sick leave benefits available to them and they're calling in sick. The employer's probably going to have to them to use that.
Can an employer, when you say verification, not everyone runs to the doctor the first day they're
Right.
sick, right?
Right.
So, I mean.
Yeah. So in this.
And also, if it's being required of an employee to, let's say, go get a note from the urgent care guy, but he's got a big deductible.
Yep.
I mean, is that the employer's responsibility? I mean, where does that?
Right. So the statute actually provides that if the employee can't get verification from a healthcare provider, then the employee can come back to the employer and say, in like a sworn written statement saying, I was using my sick leave for an appropriate purpose recognized under the statute. So the verification part of it is really kind of doesn't have a lot of teeth. I mean, the employer can say, we need you to bring your doctor's note, and all the employee needs to do is turn around and say, I can't afford the deductible, I can't get in to see my doctor, or so I have the option of providing to you my written statement. The employer can offer to pay the deductible. And it would be on the employer to be paying those costs and expenses. But if the employee says, I can't afford it, and the employer doesn't want to pay the copay, the employee then can just provide a note basically that says, sorry, I was sick, right? And if you go down there to workers' rights under that link there, it will provide you with some helpful information. It talks about the verification procedure and all the different ways that an employee might be able to provide verification to the employer.
Does this take away an employer's ability to kind of discipline on that Friday, Monday continually?
If the employee has paid sick leave benefits available to them, it does make it very challenging for the employer, right? Because you can't take disciplinary action against somebody when they're using their paid sick leave benefits appropriately.
Yeah, what if it's stop time and not paid sick? If they're just, they don't have anything.
Oh, well then no, then they don't have the protection of the statute. If they don't have any paid sick leave benefits available to them, and they're still taking Fridays and Mondays off, then we are going to a whole different training that I'd be more than happy to have with you, but it's having that ADA discussion with the employee about what is the medical condition that's preventing you from getting to work. Then you can start asking the employee for medical documentation because they have a disability that is not apparent to the employer, that's interfering with their ability to perform the essential functions of their job, i.e. coming to work. And what was that?
Only on Fridays and Mondays, though.
Right, and I mean, and it would be a whole scenario that the employer would be addressing. But if the employee doesn't have any paid sick leave benefits available to them, then they don't have any protection. Or sometimes the employee will say, I'm not going to be in today, but I don't want to tap into my paid sick leave benefits. And the employer can't make the employee use their paid sick leave benefits. But if they don't, then they also don't have the protection of the statute. And you can count it as an unauthorized or unexcused absence and leading to whenever discipline is appropriate. So if the employee doesn't want to use their paid sick leave benefits, I would say to the employee, okay, we're going to count this as an unauthorized or unexcused absence that may lead to discipline in the future. And they probably then will change their mind and decide that they do want to use their paid sick leave benefit, and that's great because then it's just burning it up. I mean,
You have to tell them, okay, this is going to be an unexcused absence.
I would tell them. I would.
If it's a problem person that's.
Yeah, there's nothing in the law that says you have to advise them of that right, or that, But if the employee says, I don't want to use my sick leave benefit, I would make sure that I would document that and make sure it's clear that the employee requested specifically that we not tap into their paid sick leave benefits. If the employee leaves employment, you don't have to pay out that sick leave benefit to them. So they've got 52 hours sitting in that sick leave bank. They don't get to tap into that, or you don't have to pay that out to them when they leave. The employer does have to essentially keep it on their books, though, because if the employee returns to employment within 12 months, you have to reinstate that paid sick leave benefit that they had at the time that they left. If the employer does want to pay it out just to get it off their books, you can. It needs to be in writing that there was an agreement that the employee, most employers are not doing that, though. I haven't found many employers that are paying out the sick leave benefit because the law specifically says you don't have to. And this particular program is administered by the Department of Labor and Industry. So that link there, again, would provide you with some more information about the paid sick leave. Authorized uses of paid sick leave are listed here. I won't go through these necessarily because I do want to jump to, because now we're over time here, the Paid Family and Medical Leave Program. So this is an entirely different program that is essentially a statewide insurance program that is providing partial wage replacement when the eligible employee is out of the workplace for a qualifying reason. It is for those the larger health events that somebody might experience in their life. It would be maybe for bonding leave when somebody has had a baby. It could be for participating in pre- and post-deployment military activities when somebody has a spouse or family member that's in the military. Those would be some of the qualifying reasons that somebody would be able to go to the state and apply for paid leave benefits. It is a program that is entirely administered by the state of Washington. It is not, the employer isn't processing the applications, the employer isn't making the payments. Those are not requirements that the employer has. So it's totally managed by the Employment Security Department. It does provide up to 12 to 18 weeks of partial wage replacement for those eligible, again, for certain events that would take them out of the workplace. It is funded by the employees by deductions from their paychecks on every pay period. There's a little bit of money taken out of each of those paychecks, and there's a formula as how the employer would calculate that. Employers that have 50 or more employees are also required to make a contribution on behalf of each employee paid into this state insurance fund. If you have less than 50 employees in your organization, less than 50 Washington employees in your organization, you are not required to make that monetary contribution, and it goes uncollected. The state doesn't go back and collect it from the employee, and it doesn't affect the employee's eligibility or the amount of benefits that they would be entitled to. So just because they work for a small employer that's not making contributions, they're not penalized in any way. Again, qualifying events there that somebody would be able to go to the state and apply for paid leave benefits would include leave to bond with the employee's child after the birth of the child or placement of a child in the household through foster care or adoption. That has to be used within the 12 months after the arrival of the bundle of joy. So somebody has a 3-year-old, they can't suddenly decide that they want to bond with the baby.
Special time with my
Right, some special time. Suddenly like, oh, paid leave benefits are available. I'm going to spend some time with my 5-year-old. It's too late. It has to occur within 12 months of the birth. To care for the serious health condition of an immediate family member, and family member is broadly defined under this state statute. It is siblings, it is parents, it is in-laws, it is grandparents, it is grandchildren, it is your own children, it is your spouse, it's your registered domestic partner. It is basically everybody but aunts, uncles, cousins, neighbors, and pets. I mean, it includes a very broad range of family members. It could be for the employee's own serious health condition. And serious health condition is specifically defined under the statute. It has to be something that keeps the employee out of the workplace for 3 or more consecutive work days where they're getting ongoing medical treatment, or it would be hospitalization. One overnight stay in a hospital might qualify somebody for this. So there is a specific definition of serious health condition. That will be analyzed by the state when the employee makes their application. So the employer doesn't decide whether the employee has a serious health condition. The employee has to fill out the paperwork, has to get certification from a medical provider that they've got a serious health condition, or their family member does. They apply to the state, and the state then will analyze that. So again, not up to the employer to decide whether the employee has a serious health condition or not. That's all going to be decided by the state. Or somebody could be taking time off of work and apply for these state paid leave benefits if they are preparing for pre or post-deployment activities for somebody who is leaving for the military.
When those things happen, is the employer still required to pay them their salary, their
No.
hourly?
No. So when they're out on leave?
Yes.
No, and that's a great question. And in fact, doing that would actually jeopardize the employee's ability to get benefits from the state. So if the employee is receiving benefits from the state, they can't also be getting unemployment, for example. The only supplement that the employee can get because they're only going to get, they'll get anywhere between 50 like and 90%. The benefit range is anywhere from $100 to $1,000 a week. $1,000 is the maximum amount that anybody would be able to get, no matter how much they earn. The state law does allow the employer to decide, and the employer should decide this up front, are we going to allow employees, when they're out on state paid leave, to tap into an employer-provided benefit like sick leave, PTO, vacation leave, short-term disability? The employer has the, first off, has the decision to make. If the employer decides that they want to allow employees to tap into those benefits, when the employee is receiving paid leave benefits from the state, those benefits are called supplemental benefits, and they are paid to the employee as supplemental benefits. They are not then considered wages or hours worked that the employer would report to the state. It's just a supplemental benefit. So it's weird that, so when they're using PTO or vacation leave to actually take a vacation, then they're just PTO benefits, and the employer would actually report those to the state on their quarterly reports as wages paid to the employee and hours worked. But when the employee is tapping into those benefits for purposes of topping off their state paid leave benefits, the employer is now calling them supplemental benefits. We're not calling it PTO anymore, it's a supplemental benefit. And the employer doesn't report those to the state on their quarterly reports as hours worked or wages paid to the employee. So they can, then if the employer decides they want to offer those, and the employer doesn't have to. So you could say, no, if you're going to apply for state paid leave benefits, you can't tap into any employer provided benefit. You can decide to do that. Decides that they want to allow the employees to tap into supplemental benefits, then it is up to the employee as to whether or not they want to tap into those. Then it's the employee's choice. The employer can't force them to do it, but the employee can if they want to. And likewise, with respect to state paid leave benefits overall, the employer cannot force an employee to go to the state, excuse me, and apply for state paid leave benefits. That's up to the employee.
Yeah, and it's similar, I think, building on this question. So our policy right now, obviously, we have to provide FMLA leave unpaid. But our internal policy is if you have, and we have a generous sick leave and vacation, you have to use it concurrent with FMLA leave.
Yes.
So,
And you can continue, and you could and should continue to enforce that as your FMLA policy.
so then if somebody wants to take this paid FMLA leave really through the state, is there any offset anywhere? Can they get that full benefit and we're still paying out
Yes.
our sick leave, so they're actually making more potentially than they would?
That is right. The employer could decide, so in probably most, I don't know how many people in here are FMLA employers, and I don't mean to get off on this tangent, but when you are an FMLA employer because you have 50 or more employees in your workplace, and you have an FMLA policy that says you must use all your paid leave benefits before your FMLA leave will become unpaid, the employer should continue to enforce that policy because FMLA is completely separate from what we're talking about here. But very likely, when an employee is out on an FMLA condition, it's also going to be something that would qualify them to go for the state and apply for paid leave benefits, and they can do that. They can run those benefits concurrently, or they can even run them end to end, where somebody then would be gone for 24 weeks. They'd be on FMLA first, and then they'd go to the state and apply for paid leave benefits and having those run end to end. So when you have somebody who is out on FMLA, and they're also receiving state paid leave benefits, there is a quirk under FMLA that says if the employee is already receiving a paid benefit from some other source, the employer's policy is essentially trumped, where you're forcing them to also use their paid leave benefits, and then basically the employer can't enforce that portion of their FMLA policy. So the employee is receiving state paid leave benefits, and you have FMLA running, then it is up to the employee as to whether or not they're going to top off their state paid benefit with the employer provided benefit. And the employer could decide, we'll allow you to top off only up to 100%, or I have a lot of employers that don't want to deal with that math and they just say, take the benefit, and the employee then ends up making 190% of their normal wage while they're out on leave. State doesn't care. There is no offset in the eyes of the state for anything that they're receiving from the employer. And likewise, there's no offset with respect to, say the employee was out on FMLA for 12 weeks for a qualifying condition, and then the employee goes to the state and applies for state paid leave benefits for that same condition. State doesn't care that they were just out on FMLA for 12 weeks. They don't even take that into consideration. There's no It doesn't offset any benefit that the employee would be entitled to under the state. But again, many of you around the table, this may not apply to because you have less than 50 employees, so you don't have to worry about FMLA. The employee's responsibilities under paid family and medical leave are fairly narrow. You have reporting responsibilities, so every quarter the employer is required to submit their reports to the Employment Security Department with the employee's name, their social security number, the hours that they worked in that quarter, and the wages that were paid to the employee in that quarter. And the employer needs to be submitting those quarterly reports. The employer is also collecting premiums from employees' paychecks at every pay period, making those premium deductions. Again, if you're a small employer, less than 50 Washington employees, you're not going to be required to pay into the system. If the employer, for some reason, though, fails to deduct the premium from the employee's paycheck, like a lot of employers, like in February and March, were like, whoa, we didn't realize we were supposed to be making these deductions from the paychecks. We'll just take it from their future paychecks. Can't do it. If you miss your opportunity to have made that deduction in that pay period, you can't collect it from a future paycheck. And the employer is going to be responsible for paying those missed premium payments. There's not a penalty, but the employer has to make up those premium payments for those employees. And finally, the employer's other obligation would be provide the employee with notice. So the employer has two notice requirements. One, they have to post a mandatory poster in their workplace where you post all your other posters about employees' state paid leave rights. And when you have an employee that's been out for 7 consecutive work days, you need to give them a written notice of their right to state paid leave benefits. And so you would, there's a notice that has already been developed by the state. You can find it at that link there, both the mandatory poster and the notice. And you would need to give that to the employee, notifying them that they have the right to go to the state and apply for paid leave benefits. Okay. A lot of questions come up about whether the employer has to continue health benefits and whether they have to restore somebody to their position when they come back from leave. If you have less than 50 employees in your organization, you wouldn't worry about either of those things. You don't have an obligation to continue their health benefits while they're out on state paid leave, and you don't have an obligation to restore them to their position when they're ready to come back from leave. But I would say, with a caveat, if you have more than 8 people in your organization, you may have an obligation under the Washington Law Against Discrimination, or if you have more than 15 people in your organization, under the Americans with Disabilities Act, to consider whether that period of time that the employee is out of the workplace is a reasonable accommodation for, if the employee's out for their own serious health condition, whether it would be reasonable for you to hold their job open for them or allow them to come back to work when they're ready to return to the workplace as a reasonable accommodation, if you can do that without creating an undue hardship for the organization. So there may be some other laws you need to think about before you fire that employee or cut them off at the knees because you have less than 50 employees and just say, we're not bringing you back to your job because we don't have to. There may be other laws that you need to think about before you cut that employee loose. If you have more than 50 people, though, in your organization, and not just 50 Washington employees, but if you are an employer that has 50 people in your organization, no matter essentially where those employees are located, you may have to continue their health insurance benefits while they're out on state paid leave if they've been on FMLA and the FMLA and the state paid leave have overlapped by at least 1 day. So if the employee is trying to do this end-to-end run with their benefits, hopefully they are, for the employee's sake, they would be smart to get that application in to make sure that their FMLA leave and their state paid leave overlapped by at least 1 day. Because if they don't, then the employer is not required to continue their health insurance benefits while they're out on paid leave. If you have more than 50 employees in your workplace, though, and this is not necessarily they don't have to be on FMLA, you may still have job restoration requirements for that employee when they're ready to return to the workplace. So employers that have 50 or more employees in the workplace, again, not just in the state of Washington, but 50 employees within their organization, probably do need to restore that employee to the equivalent position that they had at the time that they left for leave. Okay. And then the employee also has to have worked for that employer for 1,250 hours for 12 months. So it's not just like your brand new employee. It has to be restored. They too have to meet the requirements for job restoration. I'm going to end with that since I am already 15 minutes over time. But I will say at the end of those slides is a discussion about the new Non-Compete Act in the state of Washington. Yes. Yeah, and so it is retroactively applied. So if you entered into a non-competition agreement prior to January 1st of 2020 and that employee is not making more than $100,000 and you try and enforce it, it will be retroactive to that. And if you also have a clause in there that says anything over 18 months, like the employee is prohibited from working for a competitor for 24 months, that's going to be, and it will be retroactive to that agreement, regardless of when they signed it. Yeah. Wonderful. Thank you very much for your time and attention. And like I said, I'm sorry that I didn't get through all the material. If you have any, general questions, please feel free to send me an email there.